Okay, look, it's 1,000,000,000 degrees outside. I am busy playing Black Flag. I have a lot of fun, but I still took the time to read 34 pages about the Keizer Police Department. Let's do this thing. And with that, let's jump right into this story. We have discussed plenty APD over the last couple of weeks, months at this point, right? Scrutinizing decisions made in Utah, specifically in American Fork, in Provo, and in Orem, right? But we now have this 34-page document available to us. It's publicly available, and it shows us that police in Oregon, they take their job seriously, and they're not bound by what you might call it, a higher power, right? If you catch my drift. And this document actually contains 2 investigations conducted by 2 different police officers, Jennifer Starnes and Jeremiah Worledge, which that was necessary because Starnes' case was thrown out as a civil matter by the DA in May of 2025. But some PDs have capable detectives. So in chapter 1 of this investigation into the Keizer PD, let's take a closer look at chapter 1, the case that would not stay closed. This dispute surrounding Bryan Mansell's Lego collection off-rip presented itself as the kind of matter that police departments are often reluctant to treat as criminal. And I mean, for good reason, right? It involved a written contract, a failed franchise, a change in business control, competing claims to inventory, and several parties whose respective rights depended in part on how those agreements were interpreted. From that perspective, the Keizer Police Department's early inclination to view the matter as civil, that was understandable. I think you understand that too, right? I'd like to remind you that this was long before reckless Ben's involvement. However, the record that we now have, that also contains facts that make such a classification less straightforward than it first appeared. At the center of this dispute was a consignment agreement between Mansell and Crystal Law, right? Then the owner of the Bricks Minifigs store in Keizer, Salem. Under that arrangement, Mansell retained ownership of his Lego collection, while Law was authorized to sell individual items through the store. They had done this successfully for about 2 years. The agreement required Bricks Minifigs to keep records of sales, pay Mansell his agreed percentage, and return unsold merchandise after termination. Which brings us right into the middle of the action of this police report. Let's go in medias res, quote page 10. The agreement may be terminated by either party by providing 30 days written notice to the other party. This agreement shall terminate automatically on January 31st, 2025. All unsold Star Wars Legos shall be returned to Mansell within 10 days of termination of this agreement in their original condition. I cannot determine from the police reports alone if that's legally watertight, right? But it does provide an important basis for Mansell's position, because the agreement itself contemplates the possibility of succession. That's also on page 10. Quote, the agreement shall be binding on any successors of the parties. Now, whether Bricks and Minifigs Corporate or Joshua Johnson and Brendan Best or a later LLC, whether they qualify as such a successor, that is a separate question, right? But the contractual language right here, pretty straightforward. Bryan Mansell definitely had reason to believe he was in the right. The evidence also indicates that the arrangement had functioned as a genuine consignment, right, rather than as an outright transfer of ownership. Law had sold portions of the collection and paid Mansell according to the agreed percentage. In January of 2025, she returned more than 230 minifigs, approximately 12 or 13 smaller sets, and the Cloud City sets to Mansell. I think, as obvious as it may seem to you, right, this is absolutely significant because it demonstrates that at least part of the collection that Law still held onto continued to be treated as Mansell's property, even after it had been placed in the store and incorporated into its sales activity. Crystal Law still had them at home, partially because she took some of the sets and minifigs to convention, and partially because she was still conducting inventory. It was just a lot of stuff. But things get really interesting way earlier, in November of 2025. That's when, from Bryan Mansell's perspective, the relationship he has, whatever kind of relationship that is with BAM, that deteriorates. The police evidence includes a letter dated November 22nd of 2024 addressed to Bricks Minifigs and Brendan Best, notifying them of the cancellation of the consignment agreement, which is on page 11 in this document. The stated reasons include failure to provide payment and refusal to permit inspection of the remaining inventory. I'm pretty sure Bryan often went back to the store just to look at his sets. Now he wasn't allowed to do that anymore. This very same evidence submission, interestingly, also includes an inventory list of the collection. This is at the very latest when BAM had the inventory list. They always had it all along, they just didn't want to act on it. And at least one police department has had that inventory list in December of 2025. And if they'd worked together, not only to arrest and harass YouTubers, but collaborate when investigating actual crimes, then every cop in the Utah portion of this story could have had it too. But, I'm getting ahead of myself. The provenance of that inventory later becomes an important point of contention, right? Mansell tells Officer Jeremiah Worledge, who is responsible for the second investigation in this report, that the inventory was not a document he had unilaterally created after the fact. That's what BAM wants you to believe. It's not true. According to Mansell, Law had used store records to compile and correct the inventory and had incorporated it into the consignment agreement. There's also an entire history of payments made through the store, photographs of the collection, and Bricks Minifigs' own promotional material as evidence that the business had both possessed and sold the merchandise. This is not a point of contention. Bricks Minifigs' "we know nothing" policy, that's just bullshit. And the social media material collected by the police supports that story. Bricks Minifigs' Salem Keizer had publicly promoted the Mansell collection as a major attraction, including posts describing it as a large and valuable privately held LEGO Star Wars collection and advertising retired sets from it at the Keizer location. This collection was never hypothetical, and it cannot have been unknown to the business during Law's period of control. No, absolutely not. That didn't happen. But the central issue therefore concerns what happened to the unsold portion of the collection after the franchise changed hands. Mansell later tells Worledge that when he approached the new operators, he came prepared. Page 13, quote, Mansell went into the store later in the day and gave Best a copy of the inventory, a copy of the contract, and showed him his identification to prove who he was. He describes a sequence of explanations that he regarded as increasingly inconsistent. According to his account, Best initially claimed no knowledge of the collection. The explanation then shifted toward the possibility that Law had taken it, right? Followed by acknowledgements that some items may still have remained at the store. Mansell also stated that he was not permitted to inspect the sales floor or storeroom to determine whether his property was still present. In the contract, he's allowed to do it, right? We've gone over that. Now, no, not anymore, because BAM never gives up anything willingly to nobody. Keep that in mind, it will come up again. What I found very interesting is that the earlier investigation suggested that the parties would continue attempting to resolve the matter through counsel and, quote, page 9, hang on, that it needs to be resolved between the attorneys already involved. Aha, but Mansell later tells Worledge that he had never agreed to abandon the criminal complaint in favor of civil negotiation. He claims that his attorney's involvement had been limited to drafting the termination letter demanding return of the remaining property. And that's it. Even the original investigation had already uncovered evidence that complicated the purely civil interpretation of things, right? Officer Jennifer Stans reports that Joshua Johnson acknowledged that some items matching Mansell's description had been set aside. Johnson nevertheless stated that he did not wish to return those items, in part because of Mansell's continued campaign against the store, and in part because he simply believed the inventory had become part of the business assets following the takeover. So the dispute was not limited to whether property could be identified. It also involved the question of whether identifiable property should be returned. But that wasn't enough for the DA, so that first case was closed. Nevertheless, Mansell continued to argue that the existence of a civil dispute did not exclude the possibility of criminal conduct, and I think we can all agree with him here. And he let the cops know that. His position was that the relevant factual question had never been fully investigated. Whether Bricks and Minifigs continued to possess identifiable property that its operators knew originated from his collection, and if so, whether they were entitled to retain it. And eventually, in December of 2025, Officer Jeremiah Worledge was assigned to review the case and determine whether additional investigation was necessary. By then, the evidentiary record had expanded considerably. Worledge had access to the consignment agreement, the termination letter, inventory records, photographs, promotional material, videos, and the earlier police reports. More importantly, the passage of time had also produced new evidence altogether. During the months after the original case closure, the parties had continued communicating with one another, making statements about the disputed property and the circumstances of the takeover. Some of those conversations have been recorded and are part of this document. The resulting material gave Worledge an opportunity to reconsider the case on a more developed factual basis. The question was no longer simply whether Mansell believed Bricks and Minifigs had retained his Lego. It was whether the statements, records, and witness accounts accumulated since the first investigation could establish what property remained, who knew about it, and how the people controlling the store understood their right to possess it. That second investigation would eventually depend significantly on recordings. And guess who enters the story in Chapter 2, Reckless Ben becomes evidence. By the time Officer Jeremiah Worledge, began the renewed investigation, the dispute had already developed beyond competing recollections of what actually happened inside the Keizer store, right? The police file now contains written communications in which the parties describe their respective positions with considerably greater precision. I'm going to read you one of the messages Josh Johnson sent to Mansell because it addresses several of the central factual questions at once. It's on page 16 and it's dated December 5th. Johnson, I don't have an inventory list of what was sold. Here's what I'm offering. The sets that were marked with a sticker that we set aside. In return, a signed document from our legal team that you sign acknowledging that we are not responsible in any way for your agreement with Crystal and that you will take down all negative comments and things and stop disparaging us in person and online. Formal apology from you to all members of our team. Any remaining losses on your end will be directed towards Crystal Law, as it all should be. The reason I think this is so important is because it differs from later recollections of oral conversations. The police report reproduces the substance of a written offer in which Johnson himself refers to property that had been identified by its markings and deliberately set aside. Whatever legal position Johnson adopts concerning ownership, this message substantially weakens the proposition that the disputed merchandise could not be identified at all. They always knew. It also provides independent support for one of Mansell's earlier allegations. Mansell had told police that Bricks and Minifigs would not return the remaining sets unless he agreed to an NDA and apologized to the staff. So obviously that's that. So here's the question I'm asking myself now. Did Johnson ever actually believe that the new operators were not legally responsible for Law's agreement with Mansell? Or is this a BAM orchestrated grift? Is that just the way they always do it? Is this by the book? By December 5th, Johnson was communicating as though there were identifiable sets associated with Mansell's claim. Those sets had been separated from other inventory, and their return was being treated as a negotiable condition of a broader settlement. Is that BAM realizing they have made a tactical mistake and are now trying to rectify that by giving some of the Lego back and covering their asses with an NDA? And if yes, why not give it all back? Why so greedy, Emin? But back to the story. The question was no longer simply whether Mansell could prove that individual sets had once belonged to him. Johnson's own language suggests that at least some of the disputed merchandise had already been identified internally. The remaining controversy concerned the legal consequences of that identification and the conditions under which the business believed it was required, or not required, I guess, to surrender the property. This written communication also provided useful context for the recordings later supplied by Reckless Ben. On December 30th of 2025, Ben Schneider contacts Worledge and identifies himself as a YouTuber working with Mansell on this case. Schneider tells the officer that he possessed audio and video recordings of conversations that he believes are relevant to this investigation. He subsequently provides a lengthy compilation of recorded calls with Johnson, which Worledge entered into evidence as JIW6 and reviews in detail on pages 16 to 21. But luckily, we don't need to go over pages 16 to 21 in any detail because you have seen this already. It's all in Ben's first video. I just want to touch upon one little detail. One element of Ben's strategy had involved representing himself as the owner of some of the disputed Lego, right? You may remember that Ben suggested that Mansell had sold him part of the collection, thereby giving him a personal claim to the property. But Worledge did not simply assume that representation was true, because he is an actual cop. Can you believe it? On January 23rd, he contacts Mansell specifically to determine whether such a sale had actually occurred. And Bryan tells him that it had not, and that they had simply played that up for the YouTube video. So we now have a police officer verifying claims. That's awesome on multiple levels. First, it demonstrates that Worledge understands the need to distinguish between factual representations made as part of Ben's investigative technique and the underlying evidence captured by the recordings. Second, it shows that the renewed police investigation was not merely adopting anyone's narrative. Their claims were themselves subject to verification. But obviously, we need to look at how Worledge handles the other side of this story as well. And things are getting interesting in Chapter 3, the Counter-Allegation. By February of 2026, the renewed investigation had moved beyond the question of whether Mansell's collection had existed or whether some identifiable items remained in the store. Johnson's own writing and recorded statements had already suggested that certain sets had been marked, separated, and retained. No question. The investigation therefore turned toward a more consequential issue: how Bricks Minifigs itself understood its legal right to possess those items. The corporate position was not ultimately dependent on proving that no Mansell property remained in the store. Its position was a lot more unhinged and more revealing. I'm paraphrasing here, but we'll get into the nitty-gritty in a second. But they essentially say, even if some of the items had originally belonged to Mansell, we, Bricks and Minifigs, we maintain that the takeover has extinguished his ownership claim against the new operators. Officer Worledge first explores that position in an interview with Brandon Best on February 5th. Best confirms that he, yes, had been present when Bricks and Minifigs Corporate took control of the Keizer location from Crystal Law. He says that Law had fallen behind on payments and violated franchise policies, and that his role that evening was to assist with the transfer of control as a corporate employee. Best also acknowledges that Law had mentioned a consignment agreement during that takeover. However, he characterizes the reference as vague and untrustworthy, because Bricks and Minifigs did not ordinarily permit consignments. Quote, page 22. Best explained that he thought Law was making things up to prolong her stay in the store. Interesting. So the issue is no longer whether consignment had been mentioned at all. Best concedes that it had. His position now is that the statement lacked sufficient credibility or specificity to alert him to a legitimate third-party ownership claim. Say it with me, they always knew. Best further tells Worledge that the store's inventory was unusually low and that he had not observed clear markings that would identify a large consigned collection. He estimated that the store contained approximately $32,000 in inventory, but then he, quote, provided a total inventory value to corporate of approximately $17,000. Wonder where the other half went. You hauled that home, Brennan? He also says that he had asked existing employees about consignment arrangements and had been told that the store did not conduct them, which makes it, by the way, sound like a totally normal thing to do for a BAM location, doesn't it? Weird. Why does he ask them if he knows it's not allowed? But according to Best, Mansell's later contract appeared irregular, and the items Mansell claimed could not be definitely identified. Sure. Let's hear from people who lie a bit better. On February 10th, Worledge speaks with Kai McAllister and Matt McNeff, both associated with Bricks and Minifigs corporate. McNeff, Emmon's brother, in case you forgot, explains that Law had defaulted on her obligations to the franchise and owed the company more than 6 figures, which is insane. He says the franchise agreement permitted Bricks and Minifigs to seize store assets in order to offset those debts. If you now want to read more about the Bricks and Minifigs playbook, I highly recommend page 17 of this very document. It's a different section than this interview, but imagine this. If you come up with franchise costs that no franchisee can ever pay, and you repossess the store plus inventory via a corporate takeover, forgive the debt, keep the inventory, and create a new LLC that can then take over a new clean store, you too could be running your own scam empire in no time. But back to Little McNeff. He says that in this instance, corporate did not acquire individual pieces of inventory through ordinary purchase transactions. BAM just took control of the store and its contents pursuant to its contractual rights against Law. That's what they say. McAllister similarly acknowledges that Law may have mentioned a consignment arrangement on the night of the takeover. He says the reference had not been clear. And I mean, you've all seen the footage from Crystal's camera. How clear can it be? Anyway, quote page 23. But it was not clear what she was referring to because the franchise agreement prohibits consignment agreements. He said that she ended up having an agreement, but that was a violation of the franchise policy, so they weren't sure what she was actually talking about when she made mention of that night. Sure, Kai, very clever. So we got by BAM's own admission, Law may have mentioned a consignment, some items may have been associated with Mansell, and certain merchandise may have been set aside. But Bricks and Minifigs does not accept the conclusion that any of those facts mean Mansell retained ownership after corporate exercised its rights against Law. McNeff articulates that position most clearly during the interview, quote, page 24, even if there were items sitting in that store, they don't belong to Mansell anymore. Aren't you guys just the best? He then adds that the company had consulted with its attorneys and believed its handling of the matter was legally justified. Perfect. And from the way they handle their PR, I suspect their attorney's first name is, I don't know, Claude? But we now no longer need to ask the question about inventory. McNeff's statement largely bypasses them. Even if they have Bryan's Lego, it's Bryan's Lego no more. Mansell's theory, on the other hand, depends on the distinction between possession and ownership. Under the consignment agreement, Law could possess and sell his Lego, but ownership remained with Mansell until a sale occurred. Therefore, in his view, Law could not use those items to satisfy her own debts to Bricks and Minifigs because they were never her asset to transfer. Corporate's position is effectively the opposite. The assets located within the store had reverted or transferred under the franchise agreements, and any separate obligations Law had created remained obligations against Law rather than against Bricks and Minifigs. Unfortunately, the police report does not resolve which legal interpretation is correct, because, spoiler alert, this case is thrown out by the DA as civil on June 2nd of 2026. But it's clear now that the investigation could no longer be resolved simply by locating the missing Lego. Even if Worledge could establish that marked sets had remained in the store after the takeover, Bricks and Minifigs would still argue that possession was lawful because ownership had transferred through the franchise agreements. So the next investigative task was therefore not merely to determine whether the items existed. It was to find witnesses who could establish what happened to them after the takeover, how they were identified, and whether the people operating the store treated them as ordinary inventory or as property connected specifically to Mansell's claim. Let's find out in Chapter 4, The Witnesses Inside the Store. By March 2026, the investigation had reached a point where the competing accounts could no longer be resolved by asking the principal parties to repeat their positions, right? They all made their case. And you have already decided whom you believe. What Officer Worledge needs now are witnesses who had actually handled the merchandise. And he finds 2 former employees. The first, identified only as S in the report, had worked at the Keizer store for several months while Crystal Law still owned it and remained there after Brendan Best took control. She confirmed that a large collection of Lego Star Wars sets had been present in the store. She also remembered that some boxed sets carried colored stickers over their barcodes and that numerous minifigs had white strings and tags attached. At the time, she believed those markings were simply part of the store's inventory system. Nobody had initially explained to her that they identified consigned property, which changed after the takeover. This is all on pages 25 and 26. S told Worledge that the marked merchandise remained identifiable after Best assumed control. More importantly, she said those items were then removed from the sales floor, specifically because they were connected to a consignment agreement. For a period of time, they were stored in the back of the store. Her estimate, approximately 3 shelves containing 25 to 35 boxed Lego Star Wars sets, along with roughly 100 minifigs bearing the distinctive white tags. She believed the minifigs were later kept in the safe, which kinda complicates several earlier explanations, but let it slide for now. Brendan Best had told police that he did not observe obvious markings that would clearly identify Mansell's property. S remembers those markings. Corporate had described the collection as difficult to distinguish from ordinary second-hand inventory. S describes entire shelves of marked Star Wars sets being separated from the rest of the merchandise. And they were not merely present during Law's ownership. They remained in the store after Best took over. S also provides another piece of context that has little direct bearing on ownership, but is relevant to the reliability of the competing narratives. She says that Crystal Law had consistently paid her wages on time, but, quote, S additionally reported that near the end of her employment under Best's ownership, she and another employee were not paid for several months. Yeah, I think that tracks. She even described some of the conduct under the new management as potentially shady, although the report notes that she did not provide specific examples beyond the payroll issue. So this was not simply a situation in which one problematic former franchisee was replaced by an unquestionably orderly new management team. Not at all. The second employee, identified only as F, provides an account that's frankly mind-blowing on pages 25 and 26. F had worked at the store for approximately 3 years. She initially believed, based on what she had been told, that Law had purchased the Star Wars collection and that allegations had later emerged about forged documents establishing a consignment agreement. But she also states that, quote, she did not have independent knowledge of the alleged forged documents and learned of the situation after Law left ownership and Best assumed control of the store. Now, that's new, right? And I wonder if there's more to that. Obviously, that would change a whole lot about this story, right? If Crystal forged all these documents. Unfortunately, there's nothing else concerning forged documents in here. And I mean, bear with me here. These alleged rumors, could they have been started by someone who stands to gain something from painting Crystal in a bad light? Now, who could that be? Regardless, F remembers that the Star Wars sets were marked with small yellow stickers on the bottom of the boxes. The minifigs had white tags attached by string. She also recalled that the Star Wars inventory was entered into the store system under a particular designation. Her estimate of what remained at the time Law lost control of the store was considerably larger than S's. More than 60 boxed Star Wars sets and approximately 20 marked minifigs. And then she blows the whistle. Quote, F stated that after Best assumed ownership, some of the yellow stickers were removed from sets. She indicated this occurred immediately after Best took over operations, though she could not identify which specific sets had their stickers removed. So that now provides independent support for something that law had already alleged, right? The system used to identify Mansell's property was altered after control of the store had changed. I've also said that some of the marked sets continued to sit on the sales floor after Law's departure, while others, they were moved into a storage container in the back of the business. The reason, as she understood it, was the growing drama around the collection. And critically, she confirmed that the remaining items were still in the store before she was laid off. At this point, the evidentiary picture looked very different from the one presented when the case had first been closed. The issue was no longer dependent upon Mansell's inventory spreadsheet. It was no longer dependent upon Law's account. It was not even dependent upon Reckless Ben's interpretation of Johnson's statements. Multiple sources were now describing the same basic physical characteristics. Yellow stickers on boxed Star Wars sets, white tags on minifigs, marked merchandise separated from ordinary inventory, items moved into storage after the takeover, and items still present after Law was gone. So now Worledge writes that the evidence established that Mansell and Law had entered into a genuine agreement for Law to sell Mansell's Lego while ownership remained with Mansell. He found that Law had in fact been selling the property and paying Mansell. He further concluded that when Bricks Minifigs took control of the store, it also took control of Mansell's remaining property. Most importantly, Worledge writes that the available evidence made it clear that Bricks Minifigs and Best had been informed of Mansell's consigned property and knew it was present in the store. He also notes that both Bricks Minifigs and Johnson had made recorded statements acknowledging that sets from Mansell's collection remained there. He had reached a conclusion that the first investigation never had. There was enough evidence to justify sending the case back to prosecutors. So after reviewing the documents, the photographs, the recordings, the competing corporate explanations, and the testimony of former employees, Worledge referred the entire matter to the Marion County District Attorney once again. So let's talk about that in Chapter 5, back to the District Attorney. The first referral had ended with the conclusion that the dispute was civil. The May 2025 report records only that the Marion County District Attorney would not proceed because the matter needed to be resolved between the attorneys involved. Worledge now had substantially more information with direct statements from the people who controlled the business, from Reckless Ben's recordings, from Brendan Best's interview. He had an interview with Bricks Minifigs Corporate, he had Crystal Law's account. He had two former employees independently confirming that identifiable Star Wars merchandise remained in the store after the takeover. He had evidence that the identifying markings had persisted after Law's removal, that at least some marked items had been moved into storage, and an allegation from one former employee that some of the yellow stickers were removed after Best assumed control. The disputed Lego, in Bryan Mansell's view, was not simply another business asset caught up in a failed franchise. It remained his property throughout the entire process. Once the people controlling the store knew that, continued retention of the identifiable items could potentially raise a different legal question from whatever contractual dispute existed between Law and corporate. And that was essentially the question Worledge returned to prosecutors. His final report states that the matter had previously been referred to the district attorney and classified as civil, but after what he described as an extensive review of the evidence and witness statements, he referred it again for legal review and for consideration of any applicable criminal charges. 3 months later, the answer arrives and Worledge files one final supplement. Quote, "Action taken on June 2nd, 2026. The Marion County District Attorney's Office reviewed the complete case and deemed it to be civil. Disposition, case closed." There's no detailed legal analysis in the police record explaining that decision. No discussion of which criminal statute prosecutors considered. No explanation of whether the problem was ownership or intent, evidentiary sufficiency, contractual ambiguity, or simply the likelihood of obtaining a conviction. Now, I think we can all agree that the first time the matter reached the district attorney, it could plausibly be characterized as a chaotic commercial dispute involving a failed franchise, an unusual consignment arrangement, and competing claims to a large quantity of second-hand merchandise. By the second referral, the factual record was far more developed, with a complete reconstruction of the transaction. And I mean, I hope it's obvious that that alone does not establish corruption. It does not establish incompetence or favoritism. Nothing in the records supports such a conclusion. We're just left with a legitimate but unanswered question. What evidence would have been necessary to move this case from a civil dispute with possible criminal implications into an actual criminal prosecution? Because whatever that threshold was, even after a second police investigation produced substantially stronger evidence than the first, the Marion County District Attorney concluded that this case still did not cross it. And that's, I'm sorry, I don't understand that. Was the problem still the evidence? Was it the ownership? Was that the question? Was it intent? Was it the likelihood of proving the case beyond a reasonable doubt? We don't know, because the DA doesn't explain it. That's my personal frustration when dealing with these reports. For Bryan Mansell, it's particularly frustrating that he had spent more than a year insisting that police should at least investigate whether a crime had occurred. Eventually, one officer does, but even after establishing everything we talked about in this video, the criminal justice system ends exactly where it had started, with a civil case. It's conclusion time, gang. Chapter 6, Conclusion. The significance of Worledge investigation is not that it proved Bryan Mansell's entire case. It did not establish criminal liability, it did not determine the final legal ownership of every disputed set or produce charges against Bricks Minifigs. The original case had been closed while several central questions remained unresolved. By the end of Worledge's investigation, many of those questions had much clearer answers. The consignment agreement was genuine and had been actively performed by Law, who sold Mansell's Lego and paid him. Worledge ultimately concludes that Law lost control of Mansell's remaining property when Bricks Minifigs took control of the store. The investigation also substantially clarified the question of knowledge, right? Best acknowledged that Law had mentioned a consignment during the takeover, even though he said he did not consider the claim credible. McAllister similarly conceded that consignment had been mentioned. And Johnson's written communication went even further by referring explicitly to sets that had been marked and set aside, while his recorded conversations described identifiable sets and minifigs being placed into storage. McNeff eventually articulated the corporate position in even broader terms. Even if Mansell's items remained in the store, Bricks Minifigs did not believe they belonged to him anymore. That progression narrows the dispute considerably, I think. By the end of the investigation, the central issue is no longer whether Mansell's Lego could be identified, but whether the franchise takeover gave Bricks Minifigs the right to keep it. And we all have an opinion on that. Worledge tested everybody's claims against documents, opposing witnesses, recordings, and employees. He applied the same scrutiny to Ben's evidence, verifying that Ben's supposed purchase of Mansell's Lego had only been staged for the video. Worledge ultimately concluded that the consignment was genuine, that Mansell's property remained when control changed, and that Bricks Minifigs and Best knew about it. He also notes recorded acknowledgements that sets from Mansell's collection were still present and referred the case back to the district attorney only to be declined again. Now, I'm sure this feels like a setback to you. And after having seen the interview with the chief of Keizer PD on Ben's Patreon, if you haven't seen it, check it out. I'll link it down below, or I'll link the Patreon down below. I was very hopeful that we would see this case picked up and criminal charges being filed. The Keizer PD absolutely believed that to be the correct course of action. But look, this isn't over yet. And as long as we keep the pressure up on this story, I still believe we'll see the outcome we all hoped for from the very beginning. Please feel free to share this video around. I think it's refreshing to see good police work being done and subsequently talked about. We have ranted a lot about Utah, and I'm genuinely relieved to find that there are departments elsewhere doing exactly the kind of police work I've been asking for throughout this entire series. If you enjoyed this video, I'd be eternally grateful if you could click on either of the videos on screen now, as that really helps out the algorithm. Same goes for leaving a like down below, sub to the channel if you haven't, and check out my second channel for all future videos, for all future LEGO videos, linked down below. Du bist gut genug.